I'm sorry about the delay. We had a technical problem. It all sorted.
We were informed, thank you, my lord. Your lordship left me with the following question, if I've recorded it correctly, as to whether my lady and your lordship would have to ignore the big picture even in a situation where one is dealing with circular money going round and round between companies, but otherwise ticking all the boxes in active trading, etc. So I'm going to deal with that head on. The short answer, and I will develop it, is yes, for the following reason.
What, you do ignore it?
Yes, that's my answer, but I'm going to explain why, and why it should not concern your lordships and my lady in the round. Can I ask you, please, to turn to page 488, and we're going to look here at Rule 245ED, the immigration rules. So we see here it says it's headed requirements for leave to remain.
I'm so sorry, can you give that page number?
488.
488.
Yes.
Yeah.
It's headed requirements for leave to remain. To qualify for leave to remain as a Tier 1 investor migrant, an applicant must meet the requirements below. If the applicant meets these requirements, leave to remain will be granted. If the applicant does not meet these requirements, the application will be refused. We'll go through the requirements briefly in a moment. But pausing there, that second sentence is an assurance we respectfully submit by the Secretary of State to potential applicants that your application is going to be accepted by me if you meet what I now set out to be the requirements. That is the assurance. Now, that having been the case, this is a rule, therefore, that the Secretary of State has given careful thought to as to what those requirements should be. And we see that they are set out in subparagraphs A to G. So the applicant mustn't be an illegal entrant under A. The applicant must have a minimum of 75 points under paragraphs 54 to 65D, so that covers the various tables. The applicant must have been last granted entry, leave or enter to remain, and then in one of the categories set out at C. D relates to sponsorship as a Tier 4 migrant, so it doesn't apply to us. Then we have E, which we looked at earlier this morning. The applicant must be at least 18 years old, and the assets and investment he is claiming points for must be wholly under his control. The applicant must not be in the UK in breach of immigration laws, except that where 39E applies, not relevant to our purposes, any current period of overstaying will be disregarded. And G is interesting, because G is the carve-out for the, if you like, for the objective approach. The Secretary of State must not have reasonable grounds to believe that, and we're talking about money here, notwithstanding that the applicant has provided the relevant specified documents required under Appendix A, the applicant is not in control of and at liberty freely to invest the money specified in their application for the purposes of meeting the requirements of Table 7. Now, we are a Table 8B situation and not a Table 7 situation. I'll take you to Table 7 and explain how I think it works. But the point about G, before we move any further, is that it is the last of these very specific requirements, and it is an example of the Secretary of State having considered the scenario in which, as an exception to the purely objective approach, she wants to reserve for herself a subjective element. And so, standing back, I say that is why it is entirely right and proper, these are her rules, It is right and proper for your lordships and my lady to approach this by saying, well, if an applicant meets the requirements of A to G, as advertised at the beginning of 2545 ED, that is enough to entitle the applicant to leave to remain, and there is no justification for taking a long stop, big picture approach beyond that. Before I go to table 7 and the like, let me just finish that point of principle by referring your lordship and my ladyship to Procurial. I don't need to take you there, but you'll find it it's at 840, and the passage I'm about to take you to, or about to refer you to, is paragraph 42 at page 847. I'm just going to quote what is said there, and I think this is Lord Justice Sale. The Secretary of State holds all the cards. The Secretary of State drafts the immigration rules. The Secretary of State issues IDIs, instructions to officers, and guidance statements. The Secretary of State authorizes public statements made by his or her officials and then referring them to Parliament. Now, the context of that was the court saying there that in those circumstances it was not open to the Secretary of State to then pray in aid extraneous material to explain what she meant by particular parts of the rules. She's bound by the rules because they are her rules as they would be objectively understood in a common sense way by the average applicant. For our purposes, if I meet A to G requirements, I'm going to get my leave to remain. Now, can I just take you to the relevant tables and...
Sorry, which was the passage in Procurial that you got that from? Just
my lady, I got that from paragraph 42.
Paragraph 42. Okay.
On page, which I think you'll find on page 847.
Okay, thank you.
847?
847, yes. The judgment itself starts on page 840. And now, if we can turn to table 7, which my lady and your lordships will find at page 494. You will find there table 7, below that table 8A, and below that table 8B. Now, the way I understand it to work, and I stand to be corrected because there are those who are more familiar with this operation than I am. Table 7 relates, as I understand it, to a post-November 2014 situation, where the application is made after November 2014, and the basis of the application is merely money. And you'll see there that there's a requirement for money of no less than £2 million to be under the control, A, of the applicant, and then for the applicant to have opened an account with a UK-regulated bank for the purpose of investing not less than £2 million in the UK, you get 75 points for that. So that's one way of meeting the 75 points criteria. The second way, 8A, again for an application made after 6th of November 2014, the applicant has invested £2 million into the UK, share capital, loan capital, bonds, active and trading UK registered companies. Over the page, 495, we see 8B, and 8B applies, this is our situation, where entry clearance or leave to remain was granted before 6th of November 2014. And there you see that the investment required is £1 million. So it appears that what happened is that the government came to the view that after November 2014, in order to justify a Tier 1 investor migrant status, the investment needed to be £2 million rather than £1 million. I think that's the way this is supposed to work. And so therefore, although subparagraph G of Rule 245E that we just looked at refers to the Secretary of State not having reasonable grounds to believe that the money being relied on under Table 7 is not in the control and at liberty to freely invest. That applies to Table 7, but it doesn't apply to our situation. And the Secretary of State did not, and she had every opportunity to do so, consider it necessary to apply that same objective approach to the test of money under control in relation to 8B. Before I leave G, what I would also point out is even there, the issue of money not in control is raised in the context of liberty freely to invest the money specified in their application for the purpose of meeting the requirements of Table 7. So it'll come to a point I'm going to make. One needs to look at the purpose of requiring control. Now, there is, however, a definition as to what is meant by money under control in the context of 8B to be found in Rule 61A. My lady and your lordships will find that at page 500. Now, firstly, because we'll come back to this point, you'll see that it's entitled Money and Assets. And 61A, it says, in tables 7 to 9B, so it covers 8B, money of his own under his control, money under his control, exclude money that a loan has been secured against, where another party would have a claim on the money if loan repayments were not made. So that appears to be addressed to a situation where you're relying on money as the applicant, but somebody else has a call on that money for which you are claiming points. And in that situation, the Secretary of State has identified you do not have control. And understandably, because at any point you may lose that money. That third party may assert their right to that money, you will no longer have it. And if you no longer have it, it is no longer available for you to invest in a UK qualifying investment. And perhaps additionally, it may be said that you are not a person of sufficient worth. That is the purpose of requiring control, we submit. So that brings me on to subparagraph B of 245ED, and whether the test is money under control or money wholly under the control. My lady and your lordship were addressed by my learned friend on this morning, so we're going back to page 489. And I think you have our argument that we say this subparagraph E does not apply to row 1 of table 8B, where it refers to money.
Sorry, what page are we on?
489.
Oh, yes, yeah.
Subparagraph E.
Yeah, thank you.
Assets and investment he's claiming points for must be wholly under his control. We say that applies to assets and investments, and it doesn't apply to money, and there is no reasonable basis for saying that within the context of 8B, assets was intended to include money because 8B refers in rows 1 2 and 3 to money and investments and assets as separate categories to which distinct rules apply. We can see that.
But does he only apply to the particular table requirements we're considering? Or does it go wider than that? Under the table which we're considering, you make the point that,
yes,
money, investments and assets could be said to be disjunctively used.
Yes.
But E is something that must be satisfied in relation to, I'm just trying to go back to the beginning.
Yes, I think that it's fair to say that
this is a Tier 1 investor migrant.
Yes.
So it would apply to any part of the Tier 1 investor points-based structure, not just to this particular table.
I think that's right.
Right. I'm just trying to see it in its context.
Yes.
Thank you.
And the other reason why it would be wrong to ascribe E to money is that that would create a tension at the very least between E and 61A. So 61A we just looked at has a specific explanation of money under control, and it refers to a third party having claim on it. And it's very focused. And assets and investments adopts a different approach. It's another reason we respectfully submit to treat the three separately, particularly in terms of control.
So you would say 61A only considers it necessary to qualify those quoted phrases which are from the tables, and doesn't say money of his own under his control and money under his control and money wholly within his control exclude money that a loan has been secured against.
That's right. But 61A, I think, is where we get the answer to what is the reason for control. And it is to ensure that the money is available for the purpose for which it is required under the rules. And that purpose, as the Court of Appeal has identified in its judgment, is arguably twofold. One is to ensure that the money is invested in a qualifying investment, and two, to demonstrate that the applicant, having succeeded in obtaining a loan of £1 million without having to use it as security or provide security in respect of it, through that has demonstrated sufficient high net worth. And there is no dispute that the MAM loan agreement and the loan obtained from Maxwell Asset Management was not one in respect of which security was given. So that being the only objective in requiring control, what is the justification, what is the purpose then in interpreting the word control under 8b in a wider sense? We say that there is no legitimate purpose in adopting that approach. And there's no dispute that the loan was available on an unsecured basis to Miss Wang for the purpose of investment, and that it was subsequently invested in a UK active and trading company. Now, in terms of the objection, the objection that it wasn't under her control because the Maxwell scheme arrangement was deemed to require Ms. Wang to invest only in eclectic, we say even if that was a correct interpretation of the scheme, that does not mean that Ms. Wang did not have the relevant control, because it still allowed her to make an investment in a qualifying way. And as the Court of Appeal noted in paragraph 55 of its judgment, page 139, loan agreements very often contain terms limiting and defining the use to which the proceeds are to be put, and one would expect any such loan provided for the purposes of investor-migrant status to do so.
Is that very common? Why is it common?
Certainly not exceptional or unusual. If you, it depends obviously on the approach of the lender, but if you approach a lender with a stated purpose that you need money for a specific reason, it's not unusual for the lender to say, well, if that is the reason you are telling me you need this loan, I want to make sure that it goes into, it's used for that purpose, and we will put a requirement into the agreement to that effect.
But the difference between that situation and this would be that the borrower had exercised her own dominion, if you like, to decide she wanted to invest in company A, told the bank, and the bank said, okay, we'll lend you on the basis that you invest in company A, which
yes.
One can see why Sir James described that as not necessarily inconsistent with control,
yes,
because it's her own decision
yes.
that's led to the imposition of that condition.
Indeed.
But that can't be said about this scheme, can it?
Well, we say that the scheme was presented to the investors, including Ms. Wang. Let's assume, and we don't accept this to be the correct analysis of the scheme, let's assume that as part of that scheme there was a requirement, which she understood, to invest the money in eclectic. She made the choice to invest in eclectic when she decided to enter the scheme. That was clearly a choice that she made.
So is this a timing point?
It could be described as a timing point, yes.
So you're saying the element of control that you need is the moment before you enter into the loan. You've got the choice whether to enter into the loan. Once the loan's been entered into, you're tied. But you're saying, well, it's the choice exercised initially by entering into the loan,
which feeds through to the period until the investment is made, because the investment is made as a result of the choice you've made at the beginning.
Yeah, but you can't put. Well, I was going to say, but you haven't really got a choice once, in effect, the loan's being given, because you're tied into it.
In a purely legal sense, yes, but if one looks at the context in which the money came to be invested, at the point of investment, if you like, it came to be invested on our argument as a result of the choice which the investor initially made, having at the point where the various agreements were entered into, that yes, I understand this money has to be invested in eclectic, and I wish to do that.
But at the time she makes that choice, she doesn't have any control over the £1 million because she hasn't got the £1 million. She only gets the £1 million once she's entered into the scheme. She's got a choice what to do with the £200,000. She can spend it on whatever she wants. She chooses to spend it on entering into this scheme. And I can see that she doesn't lose control of the £200,000. Well, she does, because she's paid it over to the Maxwell Holdings. But at what point, then, does she have control over the £1 million?
Well, this, I suppose, is a at least part of the answer to that question is do you treat the contractual right as money.
Well, if you take the case that you mentioned of somebody who, or that was mentioned of somebody who goes to the bank, arranges to borrow £1 million to invest in a pharmaceutical company that's trading, etc. If the bank then provides the loan on the basis that the money's there for investment in the pharmaceutical company, that person has no choice about what to invest the money in, can only take the loan because on the basis that it goes into the pharmaceutical company. So it isn't exactly the same on one view position as your client.
In a purely legal sense,
Yeah.
that's right.
But that person, the difference is that that person will have exercised their independent choice about the pharmaceutical company, whereas your client is looking at an overall scheme, and the question is whether or not that makes a difference given the nature of the scheme.
I'm sorry, I may have misunderstood. I thought your hypothesis, my lord, was that in your situation, the approach was to the bank to buy shares in a pharmaceutical company, and then there was a requirement within the agreement. Or
It's in exactly the same terms. At the moment at which the money is actually invested, there isn't actually choice on the part of the investor to go and do what they want with it. If they're going to take the money, it's because it's going into the pharmaceutical company. In your case, if this lady is going to take the money, it's going into Eclectic.
Yes. To which my answer would be, but look at Rule 61A, because that explains what the choice is about. What the control is about. And the control is about whether the money in respect of which points are being claimed is subject to a claim by a third party.
But Mr. De Cruz, I'm troubled by your submission that the only purpose of the control test is to ensure that the investment gets made, which I think is sort of your submission.
It's twofold, my lord. Also to prove net worth.
Okay. If you go to Table 8B, I'm on page 495, I don't know how we can find it in all sorts of places. You get 30 points for making the qualifying investment. That's the second set of 30 points.
Yes.
Which you might call 31 to 60. And if the only purpose of the control test for which you get another 30 points, that's the control test in subparagraph B2, is to ensure you make the investment that is then described. It's a bit odd to see you're getting extra points for having that loan money under your control. I agree that's only part of the first lot of 30 points, because you've also got to have personal assets of not less than 2 million. But it suggests that having loan money under your control of not less than 1 million is a separate self-standing or part of a separate self-standing points-earning capacity about the proposed immigrant, the applicant. Separate, that is, from making the qualifying investment. Because you get all the extra points for having it.
Yes, but that would be, the answer to that, at least in part, would be it serves the purpose of demonstrating that the applicant has been able to secure, to obtain an unsecured loan and is therefore a person of high net worth. So if one looks at the
But taking an unsecured loan is only going to be evidence of net worth if the money, once you've got it, is under your control. If the money is not under your control, because it's going to go in a certain direction straight from the lender to the third party, why does being the notional borrower of that money demonstrate your net worth?
Well, if one interprets control as being confined to the fact that the money for which you're claiming does not have a claim, is not subject to a claim by a third party, yes, then that is your money in the context of the rules. Yes. It is under your control for the purpose of demonstrating that you are a high net worth individual within the meaning of 245E, the purpose described there.
So it has that additional purpose beyond ensuring that the investment is made.
Yes, sorry, I probably didn't make myself clear. And in fact, this is the way the Court of Appeal approached it. There is a twofold purpose of control. One, to ensure that it is invested in a UK qualifying investment, and 2, to demonstrate, because it is not subject to a third-party claim, because the applicant has succeeded in securing an unsecured loan, in obtaining an unsecured loan of £1 million, that person, there is a comfort in believing that that person is someone of high net worth individual within the meaning of 245E purpose.
But the Court of Appeal emphasised that their regret, as they expressed it, is that actually the way this scheme is set up, it doesn't require any creditworthiness on the part of the applicant. They've got to come up with the £200,000 up front, so there's no credit risk as regards that. And there's no actual credit risk as regards the £1 million loan, because they don't let it pass through Miss Wang's hands. It goes straight into Eclectic, which is owned by the same people as own the bank. So, I mean, do you accept that the Court of Appeal was right to say that this scheme confers, you say, my investor status, even though actually the grant of the loan by MAM was no indication of the creditworthiness of Miss Wang or any of the other 100 people who invested in it?
Well, she certainly had to provide a £200,000 fee, which is not insubstantial. But the approach which your ladyship is postulating would involve an inherently subjective analysis of the arrangements, which is exactly what the tick box approach is intended to avoid, and is contrary to the precise wording of 25ED that says if you meet the requirements of A to G, you will receive leave to remain.
So you say it's illegitimate to look at the ownership of Eclectic and MAM and say, actually, this is money going from X to X wearing a different hat.
And then using it for trading, albeit in
trading
yes, I do
in
say,
other
yes,
businesses which may also be owned by X.
which may, yes, and in this case it was shares in foreign companies. Yes, I do say that, my lady, because that is the essence of the PBS system and how it was supposed to operate and the reason it was brought in. You tick the boxes and you are assured you will receive leave to remain. And I go back to G, which is a specific carve-out that the Secretary of State reserved for herself to take a slightly different approach in one particular context. And it's her rules, and if she wished to, well, not just a G, in fact, but 61A, where there was a further explanation of what is meant by control, and if the Secretary of State wished to impose a more rigid condition in relation to control, the way to have done it is to have either included something else in 245 ED as a separate requirement, or included that in 61A.
Can I just come back to this? I mean, I'm still troubled by what I've described as the timing point. Mm-hmm. I mean, the words are, under B2, has money under his control which has been loaned to him. How can that be open to an interpretation that says you're really looking at the question of control in advance of having the money that's been loaned to you?
So the way that the Court of Appeal dealt with it, and we say correctly, is that has money under his control is to be interpreted in the context of a loan as meaning has a facility available for the purpose of being used for investment in a qualifying investment. And one has to bear in mind this particular scenario. The applicant under the Tier 1 scheme has, as you will see from row 3 months after entry into the UK to make the investment. So the applicant may well have, and quite commonly would have, secured a loan, made the application, at least for entry clearance, on the basis of the loan, but had not yet made the investment. The rules give them 3 months to do so. Now, in that situation, it would not be surprising at all if the applicant says, I'm not going to draw down under the facility yet because I'm going to have to pay interest on it. So I'll wait for some or all of the 3 months before making my investment. And it would be illogical in those circumstances to say that because the applicant has not drawn down, he doesn't have money under his control. Would be my submission.
Well, as I understand it, this test in 8B, the first portion of 8B, is a test which would have been, was necessary to be satisfied for entry clearance, is that right?
Yes, that's right.
So,
2 stages.
For the purpose of entry clearance then, what the applicant had to show was that she had money under her control and disposable in the UK amounting to 1 million, which has been loaned.
Yes.
And
Yes.
that was satisfied, as I understand it, by the loan agreement with Eclectic.
Yes.
Isn't that right?
Yes, that's right.
Yes. So that loan agreement was in place from, I think, October or thereabouts of 2013, and then she came,
Yes.
on the foot of that, she came into the UK in January 14, and then within the 3 months, on the 7th of February or thereabouts, she directed that the loan go through to, money be paid to Eclectic. Oh, sorry, what she had was the loan from the bank. She had that agreement in place.
Yeah, the agreement, yes,
Yeah.
not the loan
Yeah.
funds itself, but
So she got that agreement in place, and then on the 7th or 10th of February, she makes the Eclectic loan agreement, and that is her doing the second bit. So the problem about the interpretation of the first bit is that it was actually there to be assessed at a different point in time,
Yes.
I think.
And also, the other point, why we say this is irrelevant, is this was not a basis on which the Secretary of State's decision, which is under judicial review, was made. Secretary of State didn't say, your application is rejected because you didn't have money under your control, because all you had was a loan agreement that hadn't been drawn down. That was not part of her decision. It's not what is under review in that sense.
So what the court... Sorry.
I thought the Court of Appeal's answer to the timing point that my Lord Burrows made was that because it's accepted that you can, that the £750,000 in row 2 can be from the £1 million that you've borrowed. It doesn't have to be, but it can be that if at the time you make your application you've got the loan of £1 million, you've invested £750,000 of that, you haven't still got that part of the loan under your control because you've invested it. Query whether that investment is still under your control, but may or may not be. But that's why they said, I think, that sometimes you have to interpret row 1 as meaning you had it under your control before you made it before you invested it. But your difficulty is that she didn't have the £1 million at all until she committed to investing it in Eclectic. And as you have to look at the steps taken together, you can't say, well, there was an imaginary moment under which she did, because even under the contract, was always committed to using the money for the loan in this way.
She was committed. She was committed
Yeah.
under the contract. If one interprets it in the way that the Court of Appeal interpreted it, and I should mention at this stage, we say that wasn't the correct approach. So this is caveated on the fact the Court of Appeal's approach was correct. But I come back to that. My answer to that point, at least the first answer to that point, is none of this impacts on the critical test for control, which is there a third party? Is there a third party call on the money, on the loan?
That's an exclusion. That doesn't define what money under one's control or a loan under one's control is. It excludes from what would otherwise be
Yes.
a loan under one's control a particular class of loan.
Yeah, no, I accept that, my lord. May I put it this way, that by that exclusion, one gets the purpose of requiring control.
Well, one might say that an applicant who participates in a scheme that requires investment in a particular asset for a purpose such as we're concerned with here is not making a choice whether or not to invest the loan in that asset at all. One's engaging in a contractual arrangement which is going to result in, on payment of a fee of £200,000, an ability to make the appropriate application.
First of all, I think
Qualify under the particular provisions that we're concerned with here.
yes, but that I would submit would only be right if one completely disregards the choice made in entering into the scheme in the first place.
But if that choice has to be made before you even have a loan facility, let alone the money, and assuming you're right in saying that money may include a loan facility that hasn't yet been drawn down, you still don't have, under this scheme, you give up any control, as it were, at the moment when you get the loan facility.
Yeah, no, I see.
There's no moment where you have both the loan facility and the control, let alone the money.
As I understand it, your response to that would be, well, there may be circumstances where a loan is made available to you for the purposes of making an entirely genuine investment, but only
Not drawn down on it.
But only on the basis that one makes that investment in a particular but entirely appropriate company in this jurisdiction.
Indeed, and so if one adopts the purposive approach to that, what is the purpose to be served in disqualifying an investment or an application, rejecting an application on the basis that money isn't under the control of the applicant in that situation?
Well, one's tempted to answer that the obvious purpose is to mean that mere nominees or persons of straw don't get leave to remain under these provisions.
Yes.
Because the money would not be under their control. They would be a puppet, and somebody else will be pulling the string.
Yes. And indeed, that is the...
i.e. that the person is a person of substance with dominion over their own resources, whether they are resources of their own or borrowed resources.
Absolutely, and that falls within the exclusion or the qualification that there must not be a third-party claim. It doesn't necessarily have to be a pledge. It doesn't necessarily have to be a security in the strict legal sense of the word. It would also apply to any other third-party claim. So if the applicant is acting as a nominee, it isn't really the applicant's money. And this is the point that the Court of Appeal actually identified, an example that the Court of Appeal identified as being a reason why the test is personal availability. Is this really your money, or is there somebody standing behind the applicant that is the real, the real owner of the money, the real person who can call on the money? And that isn't the situation here.
What then is it? Oh, sorry, go on.
I was going to say, that may not be the precise case with which we're concerned with, but this may be another case which doesn't fall within the purpose of the scheme provided for applicants properly to secure leave to remain in this jurisdiction. Because in another way, this person has never had any real control or choice over the investment which is going to be made for the purpose of securing the necessary points. This is a scheme which has been presented to that person for an entirely different purpose, which is to secure the points and for no other purpose.
Yes, sorry, if my lord is developing on my lord Briggs's analogy of the applicant acting as a nominee, and I don't disagree with that. I don't take issue with that. But I say that's covered by the concept of 61A, Rule 61A.
Well, I wonder if it is. I think you're reading the phrase, money that a loan has been secured against, disjunctively from where another party would have a claim on the money. I mean, 61A should be read conjunctively, shouldn't it? It means that it's not under your control if you have given a security over that money such that another party has a right to claim on it if the loan repayments aren't met. That doesn't cover a nominee situation. The right of a nominee the right of the puppet master to direct what a nominee does wouldn't be caught by that 61A at all, would it?
I'm not
because
saying...
you wouldn't have given security to your puppet master.
I'm not suggesting, my lord, that the nominee situation that you have identified falls square within the wording of this. Within the wording of 61A. What I'm suggesting is that 61A identifies the broad purpose of requiring control, which is to ensure that the money is that of the applicant rather than any third party rather than any third party. The example that they give is a third party who has a charge, some sort of legal right to it, but it would apply logically just as well to the nominee situation which your lordship has identified. But that all fits within what we can see the mischief that 61A is aimed at.
Well, if 61A doesn't apply to nominees, which on the face of it doesn't, then it's only if you take a view that control has some meaning beyond just ensuring that the investment is made, that Table 8B, little b, the 30 points you get from that will exclude nominees.
Yes, as to that, the purpose would be ensuring that the applicant is actually somebody of net worth. Of course, if the applicant is not somebody of net worth, if the applicant is a nominee, then that applicant wouldn't be a high net worth individual meriting entry clearance. So I reiterate that my argument is that there are two purposes to control. One is that it's invested, and the second to show net worth. And any scheme which otherwise meets the requirements of A to G in that list of requirements should, under the points-based system, be allowed because there's no lack of control. The object of control has been satisfied.
Surely 8B1 is net worth. You don't need control for net worth.
Yeah. Lord, I can see why that would be the primary basis for establishing net worth.
I mean, that's what it's there for. If
Yes.
they want it to be any higher than that, no doubt they would say so.
The other way of looking at it is that money is anticipation is that money will be invested under Row 2. The money referred to in B2 will be invested in Row 2.
Yes.
And what is the...
Well, that's your point, is ensure that it's invested.
But it's
that was the first of your criteria.
Indeed, but it ensures that it's being invested by that applicant.
Yes.
And dealing with my Lord Borough's point, if the applicant is a mere nominee, then the subsequent investment under row 2 can be said to not be an investment in reality by that applicant. So that would be a justification as well.
Would you accept that B needs to be construed as an alternative to A at the beginning of Table 8B?
It has to be because of the word or.
I think so.
Yes.
So, just standing back a minute, you're looking at people, either they have their own, i.e. not borrowed
Yes.
money in the UK in excess of £1 million under their control,
Right.
or if they don't want to bring their net worth onshore, they have a net worth of not less than 2 million offshore, plus loan money in the UK under their control and disposable in the same way as if it was their own money.
Yes. I certainly agree that they are alternative ways of acquiring the 30 points under row 1.
Yeah.
And those are alternative ways to acquiring the 75 points under 8A, which is a more straightforward, you've invested £2 million in.
Correct.
So you can either invest £2 million in shares in the UK.
No, I don't think... forgive me, lady, I
Yes.
didn't mean to interrupt. I was going to say that they apply to different periods in time.
Yes.
So 8A applies to applications after,
from
after 6th of November 2014.
It's a time difference, yes.
Exactly. So before November 2014, the requirement in broad terms was £1 million investment after £2 million.
Yeah.
And Table 7 is only for people who don't fall within Table 8A and 8B, I think.
That's right. Yes. And we can see that from paragraph 55.
Yeah. But do you say that although it's accepted that the £1 million in B2 can be the money from which the £750,000 in row 2 has been drawn, if you qualify under row 1 under A that you have money of your own under your control in the UK amounting to not less than 1 million, can that money also be the 750,000, or once it's invested, is it no longer your own under your control?
No, once the A money can be used, we say, to fund the investment required under row 2. And
So
you'd still get
the B
60
money.
points.
Yeah.
You'd still get 60 points.
And so can the B money.
And so could the B money,
Yeah.
yes, absolutely. And so could the B
Because the
money.
question at the investment stage is, had money of his own?
That's right.
Yeah.
That's why the Court of Appeal said that in order to make sense of Table 8B, one has to manipulate the language in certain respects. Lord, I'm conscious of the time. No, not at all. Not at all. So I just wanted very, very quickly to mention in broad terms, deal in broad terms with the authorities that the Secretary of State has relied on in relation to the issue of control. I'm not going to go through each of them or go through them separately. Safe to say it's accepted, first of all, that what is meant by control needs to be understood in the context. It is a very quintessentially context-specific concept, and that none of the cases relied on by the Secretary of State, first of all, involve an immigration case, nor do any of them involve any situation in which statute or regulation or an agreement, etc., required the money in respect, or property in respect of which control was to be exercised, to be deployed in a particular way for a particular purpose. It was all about whether it was subject to a lien, or whether it was subject to a fixed or floating charge, or whether it could give rise to a claim of descent tort in trust, breach of trust claim, whether a property that was being managed by an operator fell within a collective investment scheme, etc., etc. It's very, very different from this. Well, my Lord and my Lady, I'm going to take my next point quite quickly because of the time, and that is to say, our discussion up to date as to control has presumed that the Maxwell scheme required Miss Wang to invest only in eclectic. Can you find out the paragraphs? We deal in detail with the reasons why, when one goes through the relevant agreements that make up the Maxwell scheme, you do not find anywhere there an obligation that the money should be used for any specific company, let alone eclectic. And
to cut things short, what you do find is a conferral of complete discretion as to where the money goes in MAM.
Is it the services agreement you're...
I can't remember if it was in the services agreement or in the MAM loan agreement. I think it's in the services agreement.
It's in the services agreement. I think I know what you're looking at.
I'm just trying to help you there.
No.
Is that your point?
It's not found anywhere, and even in the services agreement, it does not relate, we say on proper interpretation, to the initial investment that's made. And I'll show you why. Yeah, we set out our analysis of the various agreements in paragraphs 39 through to 40 or 41? 41. But I'm just going to quickly take the services agreement point. So that was starts at page 1494. And my lady and your lordships were taken to clause 3.7.4 on page 1497 earlier this morning. Now, what 3.7 does, got a number of subclauses, is identify the company's obligations as advisor and
Which page is this on?
1497.
Sorry. Thank you very much.
Clause 3.7 identifies the various obligations that Maxwell Holdings has under this services agreement. And we're taking you through it, and it identifies in broadly chronological terms the services that will be provided. The first is to ensure 3.7.1 that the loan will be obtained, that it would then 3.7.2 be used by the manager to invest in borrowed funds in the authorized instruments, plural. Authorized instruments are defined on page 1495, just observing in passing, as share capital and loan capital and active trading UK registered companies, all of which is not consistent with saying it had to be invested in eclectic. There's no reference to eclectic at all in any of these agreements. Then 3.7.3 will ensure that payments of interest on the loan are made so that the client does not incur any additional costs. And then, in this context, 3.7.4, to ensure monitoring of the client's investment in such a way that during 5 years, the 5-year period for which the migrant schema would apply, the value of the investment does not dip below £1 million, because if it does, then that will affect the right to obtain leave to remain and indefinite leave to remain. So that is the context in which we then see the last sentence. The investment has already been made. Monitoring then has to take place. And in that context, the choice of specific investment instruments needed to maintain the 1 million threshold is given by Ms. Wang to the manager to manage as her agent. It is not an authorization to pick the initial investment. And even if it was that, we would say, what is wrong in appointing a manager to manage your investments? Doesn't mean you don't have control over it. Done all the time. So that's...
So you're saying that last sentence of 3.7.4 only relates to managing the portfolio during the 5-year period.
Exactly. So for all those reasons, and the reasons set out in paragraphs 39 to 41, you will not find anywhere in the suite of agreements relating to the Maxwell scheme any obligation to invest in eclectic. In fact, there are terms which we refer to, which show that the obligation was to invest in AID companies, plural. Therefore, there was no basis, we respectfully submit, there is no basis for inferring within the scheme that there was this obligation, and the only basis upon which the Court of Appeal made that inference was the fact that all of the applicants did in fact choose to invest in eclectic. Now, none of the parties to the relevant agreements have suggested that there was, and I should say that inference was based on the assumption that there must have been some sort of additional side agreement. None of the parties to any of the suite of agreements have ever asserted that there was an additional agreement. The Secretary of State has undertaken significant investigations and interviews with the various participants into the scheme. There is no suggestion of any evidence having been uncovered of an additional side agreement or anything to that effect. In those circumstances, we respectfully submit that there is no proper basis for drawing the inference that the rights and obligations relating to the eclectic investment are anything other than as stated in the agreement or the suites of agreements.
Just remind me which paragraph it was in the Court of Appeal.
That.
Paragraph 14, yes.
Thank you. Thank you.
I'm not sure whether you're suggesting that Ms. Wang was free to invest in any authorised investment company that she wished on foot of this agreement, or?
Yes, that's what the agreement says. That the obligation, the facility was available for the purpose of investing in AID, and AID is defined in the MAM loan agreement as being UK active and trading companies, which effectively replicates the definition in Table 8B.
Well, the Court of Appeal thought that would be commercial madness on the part of the bank.
Yes.
You would agree with that?
It did. I accept that it is a very, very unusual and commercially silly agreement as far as viewed in one way, as far as the operators of the scheme is concerned. But the reality is, the context is, this was a scheme that was presented to investors whose principal priority was to get migrant status.
Get a visa.
Exactly, yeah. And they are high net worth individuals. They were not in reality too concerned about the exact active trading UK company that they invested in, and they were advised to do so religiously in relation to eclectic, and they accepted that because it provided an easy and convenient way to achieve their non-commercial objective.
So could she then, once she'd entered into the loan agreement with MAM, you say she could have said to them, please put the £1 million in my HSBC bank account because I want to buy ICI shares with it.
She could have required them to invest it in any other AID company. That was the legal obligation, is what I say. I'm just reminding myself, my lady, of exactly the wording.
Well, it's under the loan agreement that
Yes, it's-
determines the destination of the
471.
loan.
I think this is dealt with in 471. 471. Then obligations the buyer is obliged to, starts on 470, 6.1.6. Buyer is obliged to sign a loan agreement and share purchase agreement with the AID company. As I said, AID company is referred to on 469 as means company for the purposes of AID. AID is defined in the immediately preceding paragraph as investments in share capital or loan capital in active and trading UK registered companies. And then 6.1.7, to issue the lender instruction for money transfer, which we say read in context, is to transfer to the relevant AID pursuant to the loan agreement or share purchase agreement.
You don't challenge, as I understand it, the underlying fact that every single investor
I
did
don't.
have their money put into.
No, I
You're
don't.
challenging the inference which
Yes.
the Court of Appeal drew from that.
Yes, I do. And I challenge that because we have these suite of agreements.
And
We
at
have no
the very least, the inference must be that none of the investors thought they had any skin in the game so far as the £1 million was concerned. Otherwise, they might have. I mean, you don't get to be a high net worth individual, generally speaking, by being, as it were, totally unconcerned with what's done with your money.
No, of course. I mean, that may be right. They were required to pay 200,000, of course, which is not no mean sum
Well,
of
they paid
money.
£200,000 for getting the entry clearance. And
200,000.
to remain.
Yeah, they would get that back.
If you didn't get that back, you didn't get that. you got the money back.
£200,000, yes.
So that's what they're
Yes.
paying you £200,000
Yes,
for.
yes, that's right. That's right.
But otherwise, at the very least, it justifies an inference that the investors didn't think they had any skin in the game at all so far as £1 million is concerned. They couldn't make a loss and they weren't going to make a profit.
Yes, but the fact is that a loan was secured. A loan was secured. It went into an active and trading UK company under a loan agreement that they entered into, which fits what is required under 8B2.
Your submission is, for good or for bad, if they had a second and primary motive, which was to secure the clearance, that's perfectly permissible.
It's perfectly permissible because the if it wasn't, one would then have to start looking into the motives of the investors when they make their investments, and that is simply not how the PBS is intended to work.
But you may say it's the opposite, because plainly it's intended to encourage people to invest in this country, and in return they will get the clearance.
They will get the clearance, and your Lordship and my lady will recall we went through the white paper, and one of the things that the white paper identified as being a weakness of the previous system was officers having to make subjective evaluative judgments on applications. Exactly what it was trying to avoid. So trying to second guess the motives and what was going on behind the scenes, and does this really fit the broad purpose of 245E? It's an antithesis of the reason why the PBS was set up and how it's supposed to operate.
So how, on your view, does one explain the extreme improbability that they're all going to invest in Eclectic? Is your submission that they were all advised and happened to take that advice?
That's absolutely right. That is,
We're under no obligation to do that.
exactly.
They're all receiving the same advice.
They're all receiving the same advice. We don't resolve from the argument that the scheme was set up by the operators to ensure that there was investment in Eclectic at the end of the day. It's how one gets to that. And one gets to that because through the services agreement, Maxwell Holdings advised each of these investors, who are all, by the way, based in China. They don't have one can imagine, a sophisticated understanding of the investment opportunities in the UK which exact.
Well, they've all got £2 million worth of assets.
Absolutely, but their primary objective was to get the visa rather than to make a profitable investment.
That's key to your submission. You say they buy into this scheme. They're advised, in your submission as I understand it, that this will secure them the relevant clearance. It involves putting certain, accepting advice as to appropriate vehicles in which to invest. And they do that, and they do that openly.
They do that openly, they do that in good faith, they do that with regard to the requirements of 245ED A to G, which says that's fine. That is the tick box approach.
That's the submission that the Court of Appeal accepted.
Yes. And I come back to the fact that insofar as there's discomfort about the tick box approach working in this way, it has, as the examples I took you to this morning shown, worked in the Secretary of State's favour on numerous other occasions where just one looks at the substance of what is required. You haven't met it. You could have easily met it if you provided an extra document. Too bad.
That's exciting. But although you say there's nothing in this agreement that makes it clear that it's got to be eclectic, I think you do accept that they have to have signed up for the money to go to an AID company before they get the £1 million loan.
They would have realised before they get the £1 million, before they receive.
Because if you look at page 471, 6.2.1 is it's after the borrower has executed 6.11 to 6.17 of the agreement that the lender is obliged to ensure the provision of the loan facility. So they have to have signed all the documents, including the loan agreement or share purchase agreement with the AID company, and issued the lender the instruction for the money transfer. That has to be done before the lender is obliged to insure the £1 million loan.
Yes, that's right.
So I think although you may say it didn't have to be eclectic, and we don't know what would have happened if at the meeting, the face-to-face meeting envisaged in 6.1.5, Ms. Wang had said, actually, I choose something else. But assuming that would have gone ahead, she would still have had to enter into a loan agreement with the other company and issued the instruction to MAM to transfer the money before they're obliged to transfer the £1 million.
Before they're obliged to transfer it, yes.
Yes.
Definitely. I was proposing now to deal, and I'm going to deal with it as briefly as I can, with 65B. In relation to 65B, I think it's now common ground that the original decision, your Lordship to my lady will find that at 451, and the administrative review decision 440, identified, explained the reasons for exclusion as being that eclectic shared common characteristics of the excluded vehicles rather than being one of the excluded vehicles. And the issue now is whether the Secretary of State should be allowed to advance an argument that, contrary to that decision, it was in fact a pooled investment vehicle. Now we say that you should not, we respectfully submit, allow the Secretary of State to change her case. First reason is because to do so would mean allowing the Secretary of State to change the decision in respect of which there is now a review, a judicial review. This is a judicial review against the decision that she made in December 2017 and upheld in February 2018. So what you're being asked to do is to allow the Secretary of State to effectively change it at this stage, which is not the proper procedure. So she should be held to her original decision. That is what is under review. And I think it's well, in fact, I recall my learned friend accepting in terms that the Court of Appeal's finding that it was not permissible for the Secretary of State to disqualify the eclectic investment merely because it shared objectionable characteristics is not permissible. It does not comply with paragraph 65B. So that being the case, that will be our primary answer to the 65B point. But if, however, there is any interest in the argument that eclectic investment was a pooled investment vehicle, we say that it obviously was not. Paragraphs. We deal with this, I'm just going to get the paragraph references. By reference to, as far as pooled investment vehicle is concerned, firstly, guidance from the Financial Conduct Authority. Then we've also referred to a passage from the Encyclopedia of Banking that refers to pooled investment vehicle as being a species of collective investment, is a collective investment scheme. What the Financial Conduct Authority says, page 1310, a collective investment scheme is sometimes known as a pooled investment vehicle. And then at page 1491, the extract from Encyclopedia of Banking, we quote that at page 83 of our submissions. Collective investment schemes are pooled investment vehicles such as unit trusts, variable capital companies, and certain limited partnerships. Sorry, paragraph 83. And then we refer in paragraphs 84 onwards, once you get to the position that really one is looking at a collective investment vehicle, the reasons why, if one looks at section 235 of FISMA, which defines a collective investment vehicle, it is clear that eclectic is not that, because section 235 requires for there to be a collective investment scheme that it involve arrangements with respect to property or money, the purpose or effect of which is to enable the participants to receive profits or income arising from the acquisition, holding, or management of the company, or sums paid out of the profits or income. And the simple answer is eclectic was not an arrangement with respect to property that enabled Miss Wang or any other of the participants to participate or receive profits generated from how their funds were used. Their entitlement under the scheme was firstly interest at a fixed rate under the loan agreement with eclectic, I think 3.05%, and then after conversion for preference A shareholders, 2%.
Annual dividend.
Annual dividend, I'm sorry. Annual dividend.
And they had no skin in the game.
They had no skin in the game.
But such that their take was proportional to the performance of the underlying investment.
Exactly. They didn't share the risk, they didn't share the profit.
Yeah.
And if I can take it very quickly, that is the common feature of not just a pooled investment vehicle, but also an open-ended investment company, an investment trust company, and an investment syndicate company. It is not just the pooling of funds. That makes no commercial sense. It is the pooling of funds for the purpose of then investing the pooled funds in a particular way so that the investors then get to share the benefit of any profits made from those investments and, of course, take the risk of any loss. That is the essence of these four vehicles.
Could you just give me the paragraphs of your page numbers of your case on this?
The page numbers, yes, it's 111
Yeah.
to 114.
Thank you very much.
But you will see there that we analyse, also in relation to open-ended trust, there are very specific requirements. There's a definition, in section 236 of FSMA about what constitutes an open-ended investment company. And we say there it has to be regulated by the FCA, and again, it's about investment and the investors having a reasonable expectation that their return will be calculated by reference to the value of the property in respect of which the scheme is made. Doesn't apply here. Investment trust, you'll see, is referred to in the Corporation Tax Act and refers to the spreading of risks and the benefits of the members of the results of the management of the funds, and also the shares there are publicly traded. An investment syndicate company, my lady and your lordships will see there is a definition to this given by the Secretary of State in her guidance. And we quote that at paragraph
94, I think.
Thank you. We quote that. Now, the reference you will find to the guidance, I'll get that reference for you. Mr. Bryant will get that reference for you in a moment, exactly where this comes from. But the guidance says that an investment syndicate company is a pooled resource shared risk entity such as NAMECOs operating as part of a banking, underwriting or insurance syndicate. Classic pooling of risk and pooling of reward. Now, the important point about that, however, is that in that guidance, there is a definition given of this. So immediately one can see that that is a recognition by the Secretary of State that it is not possible to interpret all of these phrases just by reference to the words used.
They're terms of art.
They're terms of art, and not just in relation to investment syndicate company, but all the other three as well. There is no definition given of the other three, and the reason we say that must be the case is because those are the three for which there is some regulatory guidance. And if one has to test it, one can test it in this way. From an applicant's point of view, is it really to be said that an applicant would understand by the meaning of the following phrase what is meant by open-ended investment company?
Well, I think you said in your that Eclectic is not authorised to operate as an open-ended investment company.
Yes.
What I'm not sure about is whether an assertion by the Secretary of State that Eclectic amounts to one of these four things, a pooled investment vehicle, is an assertion that you would need to be authorised by the FCA, and you are not authorised, whether it's an assertion that this is actually an unlawful investment vehicle in the terms of being unauthorised. That may be a question more for Sir James than for you.
Yes.
Or for your junior.
I think it's common ground now that it's not suggested the Secretary of State based her decision on a conclusion that Eclectic was any of the four. It just shared common characteristics.
No, but now she wants to withdraw
now
that
she wants to withdraw
concession
that,
and
yes.
say it's a pooled investment vehicle.
Yes.
But what I'm not clear about is what the repercussions of us deciding that it is a pooled investment vehicle are for Eclectic if it needs to be, if that's then a regulated activity for the purposes of FSMA, and Eclectic is not authorised to carry on that activity.
Yes.
That you don't know.
Well, if we adopt the approach that the question of pooled investment vehicles should be analysed by reference to FSMA, what is said in FSMA, then there is no scope, I would submit, for saying it is a pooled investment vehicle even though it's not authorised. It has to be authorised.
Well, no, there can be unlawfully operated collective investment schemes, as we see from.
Sorry to interrupt.
Sorry,
this conversation. We're slightly strapped for time.
Yes.
Because of our late start. I've given you an extra.
You have.
7 minutes beyond the stated finishing time.
Yes.
We started 10 minutes late, so
Yes.
I've given you, as it were, most of the, not the consequence of the delay, but we need to give some time for the first
Of course.
to respond.
Of course. So can I? Yes. Yes. Can I just give you, if you want to look it up, the definition of investment syndicate in the guidance is to be found at 1362.
So found it where?
1362.
1362. Thank you.
So I'll deal very quickly, if I may, with the reasons why we say the Secretary of State should not be permitted to pursue a materiality argument, and even if she was allowed to do so, why they are misconceived. We set that out in paragraphs 96 to 101 of our submissions, which are on pages 115 to 117. Very briefly, as my lady in the lordship will be aware, section 32(2)A is a discretionary power. There's a high threshold, we refer to Plan B Earth for that, to meet before exercising the discretion. You need to be satisfied that it is highly likely that the outcome would not have been substantially different if the executive had gone about the decision-making process in accordance with the law, i.e. Highly likely that there would have been a justifiable reason for rejecting the application for one of the 3 reasons given, one of the 3 new arguments advanced. The first of those arguments is that the Maxwell scheme, if one stands back and looks at it in the round, did not fulfill the purpose of Rule 245E. And very briefly, we say that is wrong. Sorry, I should complete that. It argued that because it doesn't fulfill the purpose because if one stands back in the round, Ms. Wang is not said to have made an investment of any real economic substance. That's the point. Well, first of all, that necessarily disregards the loan that's made by MAM to Eclectic, and it requires your lordship and my ladyship to disregard all loans, which is plainly not correct when one takes into account row B2 of row 1 of Table 8B. Secondly, the argument is based on the presumption that Rule 245E sets out a freestanding requirement. 245E, just very briefly, if we remind ourselves.
Is this something you've already set out in your case?
I'm not sure that I did, but I'll just make it very, very quickly. That's the purpose clause or purpose rule 245E.
Yes.
And basically, it's not a requirement. It just sets out the preamble to the subsequent rules. It's the subsequent rules that set out the requirements. 245E simply explains the context in which those requirements are have been implemented.
Yeah.
That's basically that. And again, it involves a subjective approach, which is contrary to the PBS. And then it said there's no evidence that Eclectic was engaged in trading activity, but there's no analysis of what evidence there was. So this is a bare assertion as to the evidential position before the Secretary of State, and it's not supported. But in any event, if your Lordship and my lady looks in due course at page 129, paragraph 19 of the Court of Appeal's judgment, you will see that there's a reference there to trading activity. And we looked at that earlier because the trading activity was £111 million worth of trades in shares. The real complaint here is that the nature of that trading is said to have been impermissible because it was shares outside of the UK. Now, in relation to that, and this is a very quick point, your Lordships and my lady will, I hope, have our supplementary submissions about the new Rule 65AA. Now, Rule 65AA prevents now, as a qualifying investment, a loan to a company which acts as an intermediary by using those loans to invest, to make further investments. That is the classic Maxwell situation. It was brought in March 2018. It was obviously brought in, that was 6 months after Ms. Wang was given permission to judicially review. It was obviously brought in to deal with this type of scheme.
Yes. Mr. Cruz, and we will, I think it's, I mean, you said what you said in the,
yes.
In the written.
One further point, what it demonstrates, what Rule 65AA demonstrates, is there was a perfectly logical way for the Secretary of State in a drafting technique to deal with the concerns she now has about the scheme. And then very finally, the question about eclectic investment.
You now have more than your additional 10 minutes, I think.
I'm just going to ask you to look at what we say about the last point
in our
submissions.
To your case.
Yes.
Yeah.
So paragraph. What's the last paragraph? Yes, we'd refer you to paragraph 101. Thank you.
Thank you.
I'm very grateful for the additional time. Thank you.
Mr. James.
I want to start on over the interpretation approach, which my learned friend made at the outset of his submissions and then repeatedly returned to. Our submission in reply is that the praying in aid of the references, for example, in the White Paper of 2006 to certainty and objectivity and the need to try and make the thing a rules-based scheme takes my learned friend nowhere. That objective, that broad policy objective, was provided by the formulation of the rules themselves. And, if you will, although query how much it adds in our particular context, the addition of numbers and points next door to the boxes. The idea was therefore to reduce the number of discretionary elements for individual officers to take into account in their decision making. There is nothing whatever to suggest, and it would be very bizarre if the suggestion were made, there is nothing whatever to suggest that the intention, purpose or effect was to obviate the need for officers properly to understand the concepts that were being made, that were being used in the new rules, and rationally to apply that proper understanding to the facts of individual cases. That is the essence of decision making. And the question that we have been grappling with over the course of the day is what is meant by the concept of control. So that's the short answer to that first line of submissions. The second line of submissions eventually became a submission that it was illegitimate, principally for the same reasons it appears, it was illegitimate for the court to adopt an approach of looking, where one had a scheme with a variety of linked ingredients or elements, at the whole of that scheme. The standing back approach was denied as a legitimate interpretive approach for a court to take. And I respectfully submit that that cannot be right. The letter submission might have been that Rossendale was a tax avoidance scheme case and so should be restricted or confined to that context. The difficulty, of course, that would have faced is that the court went out of its way to say this is a general approach and a general principle when trying to understand what the relevant ingredients of a legislative scheme might be. particularly in circumstances in which there is a broader picture which might inform the true understanding of the individual elements of the scheme, or to characterise the concept that you have to satisfy under rules. And our submission in response is that not merely is Rossendale legitimate to be relied upon because it sets out general principles, but it is particularly appropriate for it to be relied upon in the present context for two reasons. One, because the court is here dealing with a particular species of legislation, which are the immigration rules, and you have all of the suggestions from the court that the right way of interpreting those is to adopt a realistic, non-technical interpretation, and that sits absolutely foursquare with the approach in Rossendale. But secondly, because of the nature of the scheme that you have here. This scheme bore all the hallmarks of being almost directly equivalent to a tax avoidance scheme. It was a marketed scheme, and it was a marketed scheme which had a whole series of necessarily interlinked ingredients, all of which had to be signed up to as a package, and none of which appeared to correspond to the commercial label on each individual tin in the sequence. So we respectfully submit that the correct approach is to apply Rossendale, is to look at the thing in the round, and is to take into account all of the elements, as I sought to do in my opening submissions. But thirdly, my learned friend said on interpretation that there was some support for his position, namely that the rules were just a tick box exercise, which appeared to collapse into the idea that no one was allowed to bring their individual judgment to bear as to whether or not the particular terms of the rules were met in an individual case. But it was a tick box exercise, he said, and he sought to derive support for that, as you will recall, from paragraph 43 of Pocriel. I'm not going to go back to it. That was at page 848 in the bundle. That, I submit, does not assist as a statement of principle which supports the proposition for which it was cited. In that context, as one sees from the preceding paragraph, which is paragraph 42, the context and what was sought to be relied upon was statements by Her Majesty's government. No doubt said, well, the rules are policy and the Secretary of State can make statements which might affect their meaning. And the answer to that is that that tells one nothing. And the statement of principle that followed, that you couldn't rely upon that sort of extraneous material for the purpose of informing the interpretation of the rules, tells one nothing about the principled approach to including the kind of Rossendale analysis of looking at a scheme of this kind in the round. It is simply not dealing with that situation at all. And nor, we respectfully submit, does Rule 245 ED brackets G at page 489 advance that argument either. But there is nothing in that rule to support the non-application of the Rossendale approach and principle. It's a specific rule dealing with a specific and different table within the rules. And finally, in relation to this, nor, if it's deployed as it appeared to be in part in support of this submission, you don't look at it in the room, it's a tick box exercise, nor is that submission advanced, we submit, by reliance on paragraph 61, capital A, page 500. All that rule is doing is to simply identify a particular rule or set of principles that apply to the concept of control. It does not mean that you don't have to consider the question of control. It does not mean that you have to take the applicant's word for control. It does not mean that you have to treat something which has the word loan written in it as though it conformed to the idea, even a basic idea of a loan, and likewise in relation to investment. All that rule does, as I say, is simply to identify a particular rule that applies to that concept. It is not designed exhaustively to identify purposes when you come to consider, or the decision maker comes to consider, the concept or idea of control. And we note for good measure that, as I think my Lord Briggs pointed out, it doesn't assist in any event in relation to the table 8b, because it is entirely clear that 61A, if relied upon for this different purpose, that 61A does not cover nominees. And it's accepted that nominees would be problematic and part of the purpose of the under the control doctrine for the purpose of table 8b. So far as control is concerned, a couple of small points, if I may, just by way of introduction. The first of them is in relation to assets and money, and whether assets and money are coextensive and all of that. But we simply invite you to note, by way of example, and I confess I hadn't spotted it till my learned friend went back to table 7, but we simply invite you to note that table 7 is headed assets and then solely deals with money. That's the point. You see the point? So that's the first thing. The second rather random thing is that my Lord Morgan identified or asked the question, was exactly the same rule in place at the point of entry? In other words, did you have exactly the same wording as you see in B2 at the point of entry? We haven't, I'm afraid, got the predecessor rule or the rule that governs that in the bundles, but my learned junior, Mr. Cleaver, has done a bit of computer research in the meantime, and it appears that the rule that applied at that time and in relation to entry was in substantially the same terms as the rule that you see in relation to remain, but also included that he has money under his control held in a regulated financial institution and disposable in the UK, amounting to not less than 1 million that's been loaned to him. Now, I've no idea what the position was at the point of entry. I've no idea whether there was indeed money held at that point in a regulated financial institution, so simply no idea what the position is. Perhaps the broader point in relation to all of that is that even if it was exactly the same rule, given that the same wording, or substantially the same wording, at least in part, subject to that difference, applies at the point of remain as well, there would be nothing to prevent the decision maker, and indeed the decision maker would be required to reconsider that set of issues at the point when they were considering the leave to remain application. Perhaps that's the bigger point of substance. And a third slightly random point about the services agreement, coming closer to the heart of the matter in relation to control. There was some focus on 3.7.4 within the services agreement at page 1497, and quite what power or ability Ms. Wang had at any point in time to dictate the nature of the investment. With the greatest respect, I would not accept that it's a tenable construction of 3.7.2 read alongside 3.7.4 to suggest that the client at any point in time had a discretion or ability under this sequence of arrangements to dictate, even within the band of AID companies, which AID companies you wanted the money to go to. And that is for the simple reason that 3.7.2 appears to require the manager, that's holdings, to do something within the requisite period of time, that's the 3-month investment, and 3.7.4, particularly the final sentence, makes it absolutely clear that the choice of specific instruments is at the discretion of the manager. So I do not accept that the construction advanced that gave her discretion at some point as to where the investment should go is a tenable one. In any event, and secondly, on this point, I respectfully disagree with the suggestion made by Mr. de Cruz that the Court of Appeal's analysis at paragraph 40 confined the basis for the inference that they drew that it was only going to go to eclectic to the fact that she, along with all 112 or 110, however many it was, people invested in eclectic. That was a startling fact in its own right, and perhaps would have been sufficient to provide the investment, to provide a proper basis for the inference. But if one reads paragraph 40 fairly, you will see that it isn't only confined to that. And the bull point that the Court of Appeal relied upon as forming a part of the basis for that inference was the one that my Lord Morgan drew attention to, which was that it would be an act of commercial insanity for the thing from the perspective of the Russian owners and controllers of these companies to allow that to happen, precisely because, if this is a suggestion, the money might leave their control. And it's no doubt for that reason that, as my Lady Rose pointed out, 6.1.2 of the loan agreement is deliberately sequenced to make entirely clear that no money has to leave the hands of man until the instruction of transfer is given. And so all of that, we respectfully submit, destroys the point that was sought to be made, that there was some marvellous discretion in this Wang.
So you say one doesn't have to look through the corporate veil, as it were, to see that they're in common ownership, because just looking at the terms of the agreement, whereby they guarantee the payments, that only makes sense if they still have control of the money, ownership regardless.
Exactly so. I mean, I say more than that, because I say it's clear on the face of the agreements that the power as to where the money actually goes lies in the hands of the manager. But there are lots of other points that lead to the same particular end. The bull point in relation to control, it might be thought, is that if and once it is accepted that a part of the purpose of Table 8b is to either demonstrate creditworthiness or provide some comfort that this is an individual of substance bringing their own cash to the party, it is impossible to square that, if one is allowed to stand back, as I say you plainly are, it is impossible to square that with a scheme which is set up so that the only thing that the person is able to do is to produce the £200,000 fee in relation to this. And although, of course, it is true that it's in two parts and it has a 1 and a 2, as my Lord Morgan pointed out, the second part of that, which is the 1 million under his control that's been borrowed, is an integral part of B. And it's an integral part of B because the distinction between B and A is that the money referred to in A under his own control of his own is both of his own and in the UK, and this one isn't. So this is ensuring that when you get into B, the 2 million can be outside the jurisdiction. The 1 million has got to be inside the jurisdiction if borrowed. So it has its own built-in purpose, as it were. The problem with that is it's utterly inconsistent with the way in which this scheme was set up. And the vice with this scheme is that Ms. Wang never had both the loan facility and the control at the same time. And it can't just be a choice. The requisite degree of control cannot just be a choice as to whether or not to step into the composite set of arrangements. That is simply not the way in which the scheme works, or indeed the wording works, as my Lord Burrows pointed out when identifying the sequence which appeared to exist within B2. There was, the reality is, there was no real choice over the investment made. There was no real choice about what happened to any of this money at any point in its cycle. And the fact of the matter is the scheme was deliberately set up, not so that an individual could have access to £1 million borrowed from a bank and then decide to invest in ICI. The scheme was set up to provide merely the appearance for the purpose of the rules, which is why my learned friend has to put so much reliance on tick box as the correct approach in principle. It was set up simply to create the appearance for a fee of £200,000. So that's what we say about control. So far as paragraph 65 is concerned, the answer to the point that this is to be regarded, the pooled investment vehicle is to be regarded as the same as a collective investment scheme, is provided in our case at paragraph 48. If the drafters of this scheme had been sophisticated enough to want to put collective investment scheme in, then they would no doubt have done so. They didn't. They used the broader concept, which does not have a statutory definition. So far as that is concerned, my Lady Rose asked, well, what would be the consequence of a conclusion this was a pooled investment vehicle? The answer to that is that, I think I've got this right, but the answer to that is that there would be no direct legal consequence flowing from a characterisation of this as a scheme of that kind, because pooled investment vehicle is not a statutorily defined term. If the position was that findings of fact were made that rendered this or brought this within the definition of collective investment scheme, then you might run the risk of falling within section 235 of FISMA and having to be regulated for that purpose. But we positively deny that that was the concept that was being referred to, and there might be serious issues about that in relation to the definition of collective investment scheme anyway, which requires that profits must be pooled, and that might be very difficult to apply to this scheme. The final point to make in relation to paragraph 65, and it's the final point I make in total, is that my learned friend might need to be a little careful, because what he sought to do in relation to paragraph 65, you see the point coming,
yes,
was to deny the existence of a pooled investment vehicle on the basis of a positive assertion, which, if I got it down correctly, was that they didn't share in the risk or the profit. The whole idea of this was just to create a bit of a sequence of events with a £200,000, £200,000 fee, which would lead to satisfaction of the rules. But if you don't share in the risk or the profit, it's almost by definition not an investment in the first place. So you will need to be very careful about that. That's the final point I wanted to make by way of reply. Otherwise, my lady, those were my submissions in reply.
Thank you very much.
Grateful.
Well, we're most grateful to counsel on both sides for some very interesting and challenging submissions, and indeed to all those who contributed to the preparation of the written materials, for which the court is indeed very grateful.